Oh, okay, so this is Laws 13013, Legal Professional Conduct. And hopefully you can see the little splash screen that shows you that what we're doing this week is problems 26 and 27. Okay, so I'll just revert back. God, oh, the phone will ring now. We'll revert back to the actual Moodle site for the subject. So here we go. So what I put in week 6 there is an extract from the Courier Mail a few weeks back when Brett Cowan was convicted, and it brought home to me the position of the two, the solicitor and the barrister who were representing him, because in many ways he would be viewed as a repugnant client. So the interesting thing about the little extract you can see there is that this point at the end, the pair took no joy in representing Cowan, but did it all in their power to ensure he received a fair trial. And that's really the key to this whole area about representation, in that in order for the system to work properly, you've got to have proper representation on both sides. So the person in the position of the barrister, do they have any choice as to who they represent? What's their position? So our particular barrister here on the right, Tim Meehan.
No, they don't. Cab rank rule would really take care of that.
That's right. So there's a cab rank rule which, there's various exceptions to it. So there's a bit of wiggle room with it, but the basic rule says that the barrister, it was Angus Edwards, who was the barrister on the right there, really has to accept the brief that's given to them. What about the solicitors, which is Tim Meehan in the photo here on the left-hand side? What's his position in terms of dealing with clients? Do solicitors have to accept every client that comes into their door?
No.
No. So there's a difference between the two branches of the profession. So why is there this difference? Why can solicitors make choices and barristers are constrained by not having a choice?
More solicitors than there are barristers.
There's certainly more solicitors than barristers. There's a lot more solicitors than there's barristers. So the chances of somebody being able to be represented are higher because there's more people to choose from. That's one of the arguments. Are there any other arguments about it? About that issue? I mean, that's the main one. I mean, we can leave it at that if you want, but it is important for the system to work that people can get proper representation, despite how you might, or the people involved might feel about them. Okay, so we've got two problems this evening. Problem 26 is reasonably straightforward. Problem 27 is a bit more difficult. So let's have a look at, excuse me, problem 26. So if we open that up, I'm just opening up that screen there. I went through and actually made some comments on everybody's posts, and then I just late this afternoon I put up a bit of a guide as to how to answer it. But what the question is can a lawyer make a personal conscious choice not to represent someone or even a whole section of society? For example, take the case of a fundamentalist Christian who refuses to associate with Muslims. To represent Muslims in their view would be against their fundamental Christian beliefs. And it doesn't matter what religion it is, it's the same sort of issue. So, again, is there a difference between the branches of the profession? This just talks about a lawyer. It doesn't say whether they're a barrister or whether they're a solicitor. Is the position different? What do you think?
Yes, the position is different between solicitors and barristers, just like we just said.
Okay, so let's unpack that a bit more. So where do we look in relation to the cab rank rule? Which of the barristers' rules are we looking at?
One.
Sorry, one.
Rule 21?
No, 21. I was going to say rule 1.
Yeah.
Rule 21, that's right. So if we have a look at Rule 21, if I bring up Rule 21, hang on, I'll just get it on this screen here and we'll switch over and have a look at it. Where are we? Okay. There we go. So I'm just going to switch over to a different screen here. Hopefully you should be able to see the barrister's rules there at the moment, and you should be able to see Rule 21 there. Oh, sorry, I've got the solicitor's rules. That was a bit silly. Just hang on a second. I'll stop sharing that for a second. Help if I had the right screen open, wouldn't it? Got too many screens going on a small computer screen here at the moment. Let me see. I just got to find the barrister's rules. Give me a second. I did have a copy of them in here somewhere. Where are we? Legislation, now the bar rules, barrister's rules. There we are, 2011. Just got to make them a little bit smaller because they're huge. Okay, so what I'll do is I'll just switch over and show you this screen here. That's better. That's what I wanted to show you. So if we actually go to 21. There we go, that's what I was after, the cab brake principle. All right, so if you can see that, if I made it a little bit bigger for you. Oh, not that big. There we go. A barrister must accept a brief from a solicitor to appear before a court in a field in which the barrister practices or professes to practice. Okay, so you can see some limitations there. It has to be in a field in which they practice or profess to practice. So say, for example, if they only practiced in tax law, that's all they did, then if a solicitor sent them a brief in criminal law, assuming it had nothing to do at all with tax, then that's something they don't have to accept because it's not in their field of expertise. Now, most barristers would be pretty general, particularly when they're starting out, as to what they do. But you can have an exception if it's not something in your field. And then it says, if the brief is within the barrister's capacity, skill and experience. Okay. So again, there's outs there as well. Can you see how much wriggle room there is in this principle? It has to be something within your capacity, skill and experience. The barrister would be available to work as a barrister when the brief would require the barrister to appear or to prepare. So if you've got other work on, so if you're already doing work in other cases and you don't have any time, you don't have to accept it. And the barrister is not already committed to other professional or personal engagements. So if you've got personal engagements, that again gives you an out, which may, as a real possibility, prevent the barrister from being able to advance a client's interest to the best of the barrister's skill and diligence. So there's a few ways out of it there. Another one is the fee offered on the brief is acceptable to the barrister. So if they offer you a brief and they want to pay you $100 and you normally, charge $5,000, well, you don't have to accept it if it's not acceptable in terms of the fee. And the barrister is not obliged or permitted to refuse the brief under a whole lot of rules. And you need to know those other rules, 95 through to 99 as well, because there's situations where you have to, it's mandatory that you can't take a brief, and there's situations where it is discretionary. And those things are set out in those rules 95 through to 99. So you need to have a look at those and make sure you're familiar with them. So under this general heading, so that's basically the cab rank principle. Then there's some other rules associated with it as well, because you can see that this section of the barrister's rules is a little collection of rules. It's not just one rule. So if we have a look at 22, I won't go through all of them, but 22, a barrister must not set the level of an acceptable fee for the purposes of 21C higher than a barrister would otherwise set if the barrister were willing to accept the brief. So you can't just say, that the fee's too low if it's in the range of fees that you'd normally charge. You can't just sort of get out of it by saying, oh, that fee's not high enough, if it's still within the range of the things that you usually do, with the intent that the solicitor may be deterred from continuing to offer the brief to the barrister. Okay, so I think what you should get out of this is, yes, there is a cab rank principle, and you understand what the basic rule is, that barristers have to take on cases within their experience, etc. But there is a lot of wiggle room in the rule, and the set of rules, rather, to get them out. Well, just having a look at this, this religious ground, what do you think? Does anything we've seen there suggest that this barrister, if you were a barrister in this situation, can actually refuse to represent this client if you were given a brief from a solicitor and it's within your normal range of fees, etc., and you don't have other work on? Is there any other thing in there anywhere that says you don't have to accept that brief in those set of barristers' rules?
No, I don't think so.
No, there isn't. There's nothing in there about repugnant clients, because the whole purpose of this cab rank principle is that people will represent what would otherwise be known as repugnant clients. Otherwise, you can have a situation where no one will represent them. And that means it results in a situation where the system then breaks down because they don't have adequate representation. Okay. So there's nothing in there about that. Okay, so they have a duty to represent the client and to protect their interests fearlessly and use all proper and lawful means, and you get that in Rule 37. We have a skip down to Rule 37. That's the duty to the client. If you're representing them, you have to represent them to the best of your ability. You can't do a half-baked effort because you don't like them, if I can put it that way. You're still obliged to do a professional job. Okay, all right. In fact, in Rule 5, if we actually go back to Rule 5, there's something that's getting towards the situation we're looking at here. So you can see there, you can see here the provision of advocates for those who need legal representation is better secured if there is a bar whose members must accept briefs to appear regardless of their personal beliefs. So yeah, that's really what the question is getting at. So one of the underlying principles of these rules, which are set out in Rule 5, is that you have to, take on cases regardless of your personal beliefs. You can't refuse a brief except on proper professional grounds. And the fact that you don't like somebody because of their religion is not a proper professional ground. Okay? So I think, well, probably without harping on it too much, you can see what the underlying principles are here. Okay. All right. Well, what about the position of the solicitors? Let's think about that. Now, we know from what we've talked about earlier that the cab rank principle only applies to barristers. Is there any type of rule or legislation or anything which is really going to come into play here that would suggest that this solicitor should represent this particular person, if it's looking at the case of solicitors?
No, there's not.
Sorry, go on.
According to the Solicitor's Handbook in paragraph 5.01, it expressly states that there's no duty to accept work. That's
true. You don't actually have a duty to accept work. Okay, that's true. And if you actually look at the fundamental duties of, excuse me, the solicitor's branch, if I just stop sharing the barrister's rules for a moment, and if I bring up those solicitor's ones, if you just go back to Rule 4. Okay, let's see if I can manage this. Hopefully you can see the solicitor's rules now. In Rule 4, it says the solicitor must also act in the best interests of the client in any manner in which the solicitor represents the client. So if they do take on the work, they have to act in the best interests of the client, be honest and courteous, competent and diligent, avoid any compromise to integrity and professional independence, and otherwise comply with the rules. So if they do take on the work, they have to do a proper job. But there is a piece, well, there's two pieces of legislation actually which come into play. There's one federal act and there's one state act, which are relevant to this. And we saw it in some of the answers that people have been putting up on the discussion thread. And it's all about the Anti-Discrimination Act and legislation. Now, not all of the answers mentioned this, but the ones that did focused on the Commonwealth Act. They didn't seem to realise there's actually a state act as well. So I'll concentrate on the state act. So this is the Anti-Discrimination Act 1991 Queensland. And if we have a look at that, I'll just bring up the provisions and you'll be able to see that. Let's see, where are we? Yeah. Okay, so what I've done there is I've got the various provisions of the Act. So you can see there in section 46 of the Act, discrimination in terms of goods and services. Now we're looking at a service because that's what solicitors are doing. They're providing a service. So a person who provides a service, doesn't matter whether they make a profit or not, cannot discriminate against another person by failing to supply the service or by treating the other person unfavourably in a way in connection with the supply of goods and services. So you see, that could well come into play in this situation. So to deny somebody on grounds of religion may fall foul of this act. So let's see how that comes into play. If you have a look at services, you can see in section 4F, services of any profession. Well, that's going to include the profession of being a lawyer. You can see in section 7, discrimination on the basis of certain attributes. And look at number I, religion. Okay. And also, if you don't associate with or in relation to a person identified on the basis of any of the above attributes. So if you refuse to associate with them as well, that's a form of discrimination. The Act actually prohibits direct discrimination. So what is direct discrimination? That's in section 10. So direct discrimination on the basis of an attribute happens if a person treats or proposes to treat a person with an attribute, namely a particular religious attribute, in this case, less favourably than another person without the attribute or would have treated in the circumstances that are the same or not materially different. So what it's saying is that potentially this Muslim person, in our example, could take this lawyer on under the Racial Discrimination Act in Queensland. And it doesn't matter what the motive of the lawyer is for discriminating, it's irrelevant. So you can see there the example, R refuses to employ C, who is Chinese, not because R dislikes Chinese people, but because R knows that C would be treated badly by other staff, some of whom are prejudiced against Asian people. R's conduct amounts to discrimination against C. The same argument, similar sort of argument can be mounted in this situation about denying a service. So potentially this could apply to barristers as well, if you think about it, because they're supplying a service as well. The only slight problem with them is that the service, they're actually hired by the solicitor, aren't they? So they don't have a contract as such with the client, they have it with the actual solicitor. The only exception to that, I suppose, is that you do have situations where the barrister can work directly for a client, and it would certainly apply there. So there's provisions that you don't actually need a solicitor, but it's pretty uncommon for a barrister to work directly with a client, although it's permissible, it seems, under the barrister's rules, if you have a look. So that's something you should bear in mind as well in relation to this particular problem. Do you have any questions about that? And it's very similar under the Commonwealth Act as well. I've just concentrated on the state one, which is going to apply in our situation. Any questions about that?
Yeah, Stephen, on that scenario, it's going to be pretty difficult to prove that was the person's only reason to knock back the work or not do the work. It would be pretty difficult to prove, wouldn't it?
Well, it would be hard to prove. You'd have to be very careful as a solicitor, wouldn't you? If you were this way inclined, you'd have to be very careful that you didn't create any evidence that could ground this. You certainly wouldn't put anything in writing, But even how you deal with somebody, they can still write an affidavit saying that I approached the lawyer's firm wouldn't talk to me, they wouldn't take me on as a client. It just depends on what happened and what were the exchanges of communication and information. But that's probably as far as we go, because it just depends on what the circumstances were. But I agree. I mean, you've got to have evidence to prove it.
It's certainly different if the person comes in and says, I'm a fundamentalist Christian and you're a Muslim, therefore I'm not going to represent you. That's straight up and down. But to sit there and look at a case, I probably can't advance your cause for X, Y, and Z. Therefore, I think that it's probably best I not represent you. It's going to be pretty difficult in those circumstances, I'd think. But again, it's only a basic question, I suppose.
Well, that's right. But anyway, it's something that you take into account when you're considering a question like this. All right. I don't know, Louise, did you have any questions about this problem?
No, I was going to ask something along the same lines as what Luke just asked. So.
Okay. No, that's fine. All right. Well, look, we'll move on to problem 27. I've got that listed here. This one's actually quite difficult in some ways. I noticed on the discussion thread people were having problems with it. There were, we're getting quite good responses on other questions, and this one only had a couple of responses. So basically what it's doing is asking you to have a look through this case of the Queen against White. And what I've done is I've just highlighted various bits of it as I went through. So I'll just run through it in terms of what happened, and then we'll have a look at what questions there are. So what happened here is that counsel for the accused, I guess that was a criminal matter, and there was a jury. So you can imagine you're in a courtroom, you've got a judge, you've got a jury, you've got prosecution, and you've got the defence counsel. So the defence counsel for the accused, proposed to withdraw during a murder trial, and it was estimated to last 10 weeks. Okay. Its primary reason for the notice of withdrawal was that he had been dismissed by his client and it had become impossible for him to communicate with the accused. So he's having problems with communication and getting instructions. And he said that therefore he had been unable to obtain instructions. Further, he requested and had received advice from the bar counsel, so he sought advice from senior counsel, that he should withdraw. Counsel also submitted to the court that he did not require leave to withdraw. So there was an issue as to whether leave was required. In other words, did he need the permission of the court, the granting of leave, to be able to withdraw or not? And basically it came on before an acting judge, AJ, acting judge Barr, and two other reasons came out for the effective seeking this leave to withdraw. One was that the counsel was diametrically opposed to the view that the judge had taken concerning the accused's fitness to be tried. So obviously the counsel was concerned that this particular accused wasn't fit to be tried. In other words, he had, in this particular case, some sort of mental issue, I think. So that was one issue. And the other one was that there existed a conflict as to who, in fact, represented the accused and had the power to give instructions in the trial. So this particular accused, if you look through the facts, had been subject to an order under the Guardianship Act. So there was a question as to their mental fitness. And usually what will happen if somebody is of a type of incapacity, then a guardian will be appointed, and that guardian will be the one who gives instructions to the solicitors and ultimately to the barrister. So there was an issue under this Guardianship Act, and it seems that the actual Guardianship Board had determined that the accused was fit to actually make their own instructions, okay? But the trouble was the barrister didn't think that that was a correct decision, that their experience with the accused was that the barrister didn't think they were fit to give instructions. And in fact, he couldn't get instructions from this particular client. So this is a really awkward type situation to try and resolve. So The judge makes a comment that Section 13 of the Mental Health Criminal Procedure Act requires that trial of the accused on the charge of murder should continue, and that what should happen is if there is a question as to their mental capacity, then that argument needs to be put before the judge, and the judge makes a ruling about that. Now, in fact, that wasn't what the defence counsel proposed to do. And they were more in terms of making comments about wanting to withdraw because of the impossibility of communication. They didn't have instructions. The judge was pressing the counsel. You can see here, Mr. Coombs later informed me that he would have no ethical problem in appearing on a further unfitness to be tried inquiry. So that's the unfitness to be tried inquiry is an inquiry or a question put to the judge to make a determination whether the accused is unfit to be tried because of mental, in this case, mental incapacity, despite what the guardianship board had said. But so he didn't have an ethical problem in appearing on that. But in fact, what happened is that that didn't actually happen. No one actually pursued that unfitness to try inquiry. Okay. He also, the barrister also said that after he withdrew, then the solicitor would continue to represent the accused. So they still had somebody representing them, albeit a solicitor. They, the Crown, so what did the prosecution have to say about this? They were not opposing the application for leave to withdraw, so they didn't have any problem with it. But what they would object to would be an application for unfitness to be tried hearing. So they didn't want to have that. They wanted to pursue the prosecution. They didn't want to have an argument over the fitness of the accused to be tried at all. And they also indicated that they would object to any adjournment. See, if somebody's unrepresented, one of the things that courts often do is that they will have an adjournment to give time for the accused to obtain other counsel. And the Crown's saying that they would basically object to that procedure from happening. Okay, so the next thing that happened, or rather didn't happen, is that neither side has tried to raise the question of the accused's unfitness to be tried. So that didn't become an issue at all in this whole little scenario that's playing out. Okay, all right. So what was the relevance of the barrister going off to the Bar Council and seeking their advice? You can see here the judge says, I accept, of course, that the Bar Council may inform or direct a barrister from time to time what the etiquette of the bar requires, and in that sense, the rules which govern the conduct of the barrister are in no way confined to printed and published bar rules. So you know we've got bar rules, but if you've got something that doesn't fit within the bar rules, which is what's happened here, you can seek a ruling from the Bar Council or from a senior, like a QC, a Queen's Counsel, Senior Counsel, as to what you should do. So the fact that the situation is not covered by the bar rules, the printed things we've been looking at, is not the end of the matter. You can get help and assistance from senior barristers. Okay, so putting that issue to aside, the question was, did the court have any role in deciding whether a barrister should be allowed to withdraw or not? In other words, did they have to give permission, or can the barrister just tell them and the court notes that rather than giving leave? So the judge then goes and looks at other jurisdictions and says there, it's well recognised in other jurisdictions that trial courts exercise their discretion when counsel wish to withdraw. So if you're exercising a discretion, then you're in effect giving leave. Okay. Then there's a summary of what happens in other countries, and there's various debates about, and there's some Canadian provinces which go either way. He also makes the point that a point of distinction between the case that he's dealing with now, this murder case, and some of the other examples that were given overseas, is that if a counsel withdraws in a murder trial in Australia, the trial continues. It doesn't stop. It continues even if the accused is unrepresented. There might be an adjournment to let them get represented, but it nevertheless continues. So he actually concludes in the end that the discretion does exist, however, that there are limits to that discretion. And that then gives rise to this particular example of a case of Shaw, which is in 1980, English Court of Appeal. Now, this is an interesting one because what happened here is that you had an appellant, so it was an appeal, but the appellant absconded during his trial. He actually escaped and essentially left the barrister standing there. So his counsel remained representing the accused who's absconded in the middle of the trial. And what happened, he sought the court to discharge the jury and order a new trial. The trial judge refused and directed the trial to continue. His Honour went on to pronounce that as the defendant had voluntarily absented himself, which is an interesting way of putting it, isn't it? He escaped from police custody. He voluntarily absented himself. He must be taken to have withdrawn the instructions that he'd given to his solicitor and counsel. See, that's very odd. Why would you conclude that? Why would you conclude because he's escaped that he's withdrawn his instructions? Anyway, His Honour therefore refused to allow counsel to take further part in the proceedings in spite of the fact that counsel wished to do so and considered himself instructed sufficiently for the purpose. It goes off to the Court of Appeal. The view of the Court of Appeal, it was not within the province of the trial judge during a criminal trial to dismiss a counsel or solicitor or order them to remain if counsel were required by the etiquette of the bar to do otherwise. So you can see there that the judge really didn't have that entitlement to remove the counsel. And it also brings into play this notion of what the etiquette of the bar would suggest. Then he says, here, Mr. Coombs, as I accept, has sought the advice of the bar counsel and other senior counsel and tells me that the etiquette requires him to withdraw. The Shaw case is not binding on this court, but it's nonetheless, a strong precedent. And he doesn't see any reason why he should not follow it. Okay. So he then concludes, it seems to me that although this court may have a general discretion, it may not extend to a case like the present one where the counsel is obliged as a matter of professional etiquette to withdraw. Alternatively, the matter may be that although a discretion exists, it ought not to be exercised against the grant of leave in those circumstances. So he's sort of sitting on the fence. He's saying, if I do have a discretion to grant leave, then it's not one that I should exercise against the granting of leave. It's a circumstance where there should be leave, or the other way of looking at it, as a matter of professional etiquette, the judge should take that into account in the circumstances and just acknowledge that the counsel's withdrawing and that they don't need to give leave. And then he says that it's the differences of little consequence. And the last thing he says, if the better way is to approach the matter on the basis that there is no discretion in the court in the circumstances, it would be appropriate for the court merely to say that Mr. Coombs, that's the barrister, that the barrister's withdrawal is noted. If this be wrong, the discretion should be exercised in favour of a grant of leave, and I would exercise it accordingly. Okay, so what, in the end, is this case telling us? The sorts of points you get out of it, well, maybe you can tell me before I tell you what I'm thinking, but what are the main ideas you're getting out of this particular case? Any suggestions?
Can I just ask a question, Stephen?
Yeah.
Did the accused actually dismiss counsel, or was it just based on that counsel wasn't getting any instructions, so therefore he takes that?
They just weren't getting any instructions. So I mean, you could argue it was a constructive dismissal, but it certainly wasn't a case where the accused says, "No, you're sacked. You're no longer my counsel." It's just that they stopped giving instructions.
Okay. Yeah.
All right, what else do we get out of this case? The reason I put it here is that it's a difficult case. See, not everything we see is nice, clear-cut, packaged, and you can make a really simple determination. This is an example of something where it didn't fit any of the rules, and it was a difficult situation. And it's, it's a murder trial. You've got a jury sitting there. You can imagine what's going on. There's 12 people sitting there in the jury box. There'll be press. Murder trials always generate a lot of public interest. You've got a situation where the accused is borderline mental issues. Are they somebody who can actually give instructions? They've stopped talking to their barrister. Barrister's standing there figuring out, well, how do I, present a case when I can't get any instructions from the client? You see, they're in a very difficult situation. Then they've got, on the other side, they've got the Crown saying, well, let's get on with it. There shouldn't be any adjournments. Let's run the trial. And then you've got the judge sitting there trying to make determinations on whether this particular barrister should be excused. Because if the defence counsel leaves, what are you left with? If you're the judge, you're looking at a courtroom with an accused whose mental state is questionable, and their solicitor. It's not a really good situation in terms of conducting a fair trial in a murder situation, or any situation. So you can see how if you can imagine that type of situation, it's pretty tense. What other sorts of things do you get out of this?
Stephen, I got that it was a pretty interesting case to have a read through, and it was, well, firstly, I suppose the main point was, he able to seek leave, or was he able to withdraw? And underlying that was, it seems to be that he wasn't satisfied to be tried. And he seemed to hide behind that. And then it goes into the guardianship as well, getting to the point that, yes, okay, sitting on the fence, yes, if there's an avenue to seek leave, I accept that. However, if you wish to withdraw, I'll note that as well.
Yeah, you see, the judge is sort of sitting on the fence a bit, isn't he? But the net result is the same.
In coming to the last question, I had a pretty good hard think about that, and that's what I come to too, that he didn't necessarily say that the professional etiquette was prevailing over the custom to or the discretion of the court to withdraw. I thought he was having, a bit each way.
He was having a bit each way. There's an important concept you need to understand in relation to discretions. Basically, discretions, wherever you see the word may, a judge may do something. So may is telling you it's discretionary as distinct from the word shall or must, which means it's mandatory. So wherever you see the word may, there's a discretion within the rules. So where there's a discretion, there's an important principle that you shouldn't fetter the discretion. And what that means is that you can't specify situations when the discretion should not apply. In other words, if you say, in this situation there's no discretion, that actually removes the discretion. All you can say is that these are factors that you take into account when exercising the discretion. And if you put it that way, the discretion still exists, but you can take into account all sorts of factors. But you can't say any one of those factors is determinant of itself, because if you do that, you no longer have a discretion. It becomes mandatory. So, here you could think about, well, is etiquette? You can't say that if you've got an etiquette ruling by the Bar Association or the Bar Council in this case, that is going to fetter the discretion of the judge if they have a discretion. Okay? So it's something they can take into account in the exercise of their discretion. That's one way of approaching it. And the judge, by sitting on the fence, so that's on one side. On the other side is to say, well, there is actually no discretion in this situation. It's just something that the court will acknowledge that the counsel is withdrawing. It doesn't have to give leave for them to withdraw. So they're the sort of two sides to it. But it does bring out this notion of of the role of the etiquette of the bar and that helps resolve difficult cases like this where it doesn't fit within the rules. And also it does show you the discretion of the court. It's actually part of its inherent jurisdiction to control its own processes. So that would have been another way this judge could have looked at this. Didn't, but could have, is to say that the court has inherent jurisdiction to govern its own processes, and that that would include the giving a leave for a barrister to withdraw. Now that argument didn't come up in the case, but it could have. So that's another factor with this particular case. The real this second question here: why would Mr. Coombs have ethical problems concerning an inquiry by the court into the accused's unfitness to be tried? What did you think about that one? Isn't his ethical problem is that he doesn't have any instructions. He can't actually represent the client in relation to that matter because he doesn't have any instructions to do so. See, it says that Mr. Coombs has no ethical problem in appearing on further unfitness to be tried inquiry under that section of the Mental Health Act. That would have been fine if he had instructions, except the instructing solicitors would not give such instructions, as Coombs would be unavailable at the time of the inquiry. He also had a problem. He also had this personal conflict in the things. In essence, he thinks the client, the accused, is mentally ill and unfit, and that, and he's got a problem with representing this person. He could no longer represent them because he couldn't get any instruction. He wouldn't talk to it. He couldn't get any instructions. So there's the conflicts this barrister is suffering from. So basically, he has no instructions, so he can't continue to act. But he wouldn't have had an ethical problem if he could have got instructions. I think that's the principle that's coming out of it. So there's this other one. How could Mr. Coombs state that he was dismissed by the client when he said over the last few weeks the accused had sacked him? Well, did he actually say that? I'm not sure he did say that. I don't think it's a case the accused had sacked him by saying that. It was a case of the accused saying nothing. So at best you might be able to say that it was a constructive dismissal. But given the dilemma, what Coombs did was to go and talk to the Bar Council to get a ruling as to what he should do. And that's where this etiquette issue came into the case. So that's an example of a hard case, one that doesn't fit within the normal boxes of where we would put things. And you're going to encounter things like this in practice. Not everything fits into a nice, neat little package. And when you're presented with a client, they will give you all sorts of facts, for example, that really come under three categories: relevant, irrelevant, or missing, the things that they don't tell you. So part of your job, they don't turn up with a nice little scenario with everything nicely set out and then ask you, well, what's the legal position? It comes in a whole jumble of things. They'll have things that are relevant, things that aren't, and things that are missing. And it's the missing ones that are really the important ones to focus on. You have to look at, well, what is the client telling me? Firstly, do I believe what they're telling me? Is it substantiated by any documents or other facts that you can ascertain from independent sources? Because you can't assume the clients will actually tell you the truth either, by the way. You always need to be on your guard as to what people say to you. And then you look at, well, does the story they're saying actually make sense? And also, what are the bits that are missing in terms of whatever the legal problem is? Say it's a contractual dispute. Are all the elements of the contract there? Or if it's a tort matter, are all the elements of the tort there? What other things do you need to ask? So they're the sort of questions. The law school gives you everything in a nice, neat little package, and it's a bit deceptive in some ways. What we should do is give you some more problems that have missing elements in them, so that you become more attuned to that. And this case here, I think, is a good one because it's got a lot of problems with it that don't fit within the normal boxes, and that's the sorts of things that happen in practice, not all the time, but that can arise, and you have to try and work out a solution to that. And the rules may not actually give you one, in which case you've then got to, if you're a barrister, go off to the Bar Association. If you're a solicitor, you can, talk to the Law Society about it as well. So anyway, that was the whole idea of giving you that problem. And I think it was effective just by looking at the very limited number of responses I got on the actual discussion forum, because it was, you look at it and, how do I deal with that? Okay, all right. Have you got any questions about that that particular problem? You sort of see the points in it now and how to resolve them?
Yeah. Yes, I can.
Okay. What about you, Louise? I don't know if you're comfortable with that problem, but do you see what we're getting at with it?
Yeah, I do. And I always thought when I read this today, actually, and because I always thought if it was in the middle, if the trial had already begun, that you would need leave the court to withdraw.
Well, in a obviously in this particular criminal matter, there was a debate about it.
Yeah, that's what I found interesting, actually, because I just thought that you needed leave of the court if the trial had already started and you're in the middle of it. I thought that you would need leave.
Yeah, but where's the, you always got to look, where's the rule that requires that? And sometimes there just isn't one.
I thought I read it somewhere.
Well, if you find it, bring it up. But certainly in the context of this, when this case was determined. So when was, I'll just go back, what year was it? Where are we? 1995. I mean, it's not that old, really, in the scheme of things. And when you look at the history of the law, it's not that old. So there you go. All right. Well, that's all I had to say. About all of this. I hope the readings. I hope you're finding the readings a bit more manageable. I was always a bit concerned about week 4 because of the amount of stuff in it, but I think from now on it's quite reasonable in terms of getting through it every week. If you have any problems, or anybody who listens to the recording has any problems, just post up the question on Moodle, or send me an email. Either way, it's probably better to put it up on Moodle, because if somebody's got a problem, that probably other people are thinking about the same thing. And that's really all I can say, I suppose. Okay.
Steve,
yep.
Sorry, can I just ask you, for the next assessment, for that client interviewing assessment?
Oh, yeah. Yep.
When is that going to have to be done on either the 12th or the 13th? Is that right, of May?
I think the way to do it is it'll be done online. So you'll be in groups of 3, and I think I'd rather have people select their own group, and that group can negotiate a time at which they're going to do the exercise. And the exercise will involve 3 short client interviewing situations. So there'll be 3 scenarios. I haven't written them yet, but there will be 3 scenarios. And so there will be a client, there will be a person conducting the interview, and then the third person will be viewing it. And it's the third person's report which is being assessed. So what will happen is that the first scenario, remember it's repeated 3 times, so everybody will be in each of the roles. And so everybody will write a report on what they're observing the other 2 students doing. And then they will give that report to the other 2 students at the conclusion of the process. So it's the whole design of it is to give you firstly some readings, and I haven't found them all yet, but I'll give you those about client interviewing generally, and then you'll have this exercise which you'll be involved in, and then you'll get your reflections on that process. The other thing, by the way, to watch out for if you're interested is there's opportunities for clinical practice as well. Wayne Jones and Anna Farmer and Lance Rundle have been doing quite a lot of work in setting up arrangements with community legal centres for either research, or I think there'll be opportunities for client interviewing as well, with real clients supervised via the internet. So if you're thinking about something like that, there'll be opportunities for that coming up as well. Probably more likely to be next term rather than this one, but certainly encourage people to think about that, because they'll start to see real things as opposed to us inventing scenarios all the time. So that might be something that you might be interested in. So these sorts of exercises we'll be doing will have some practical relevance when you start to become involved with some of those clinical aspects. And we'll be putting those clinical aspects into various subjects as well. Instead of having a clinic subject, which is what a lot of law schools do, what we think we're going to go down the approach of actually embedding it in different courses so that you get some real world type experiences as you're going through and to see how things practically apply. So the exercise you'll be doing in relation to client interviewing will be useful later on when these clinic things are in place. So there's all sorts of things about to happen. All right?
Yeah, sounds good.
Okay. Well, look, we might... Sorry, so go ahead.
To the assignment, that will be returned 2nd of May, or is there extensions that may push that back?
No, I should be able to return those as I mark them because they're all unique. So I haven't started marking them yet, but when I do, I think I might mark a batch of 5 and then return those and do another batch of 5 and return those because each one of those is unique. It's not like a normal, it's not like an assignment where there's one question and everybody answers that, and therefore you've got to wait until all of the particular responses have been put in. So I can actually release them as I go. So I'll probably be doing that. Okay.
Yep, that sounds good. Thank you.
Okay. All right, we'll stop there. I'll see you next week.
Thanks, Stephen.
See you then. Thank you.
All right, bye.
Bye.
Bye.